Thank you. That's brilliant. So good morning, everyone, and a warm welcome to this event run by Greater Birmingham and Solihull Growth Hub. I'm Christine Hancock. I'm an account manager from the Growth Hub, and it's great to see you here today for this event, Trading with Europe, Where Are We Now and Where Are We Headed? So I know there's many familiar faces here this morning, and a lot of you are already working with the Growth Hub. But for those few of you who are new to us, the Growth Hub offers free business advice and support and access to funding to businesses in the Greater Birmingham area. So we work with a wide range of partners, such as chambers of commerce, enterprise zones, banks and universities. So we coordinate all the local business support. So if we can't help you directly, we can connect you with someone who can. So today we're delighted to welcome our expert speaker, Tim Hiscock from Strong and Heard. Tim's going to talk us through the key challenges and update us on anticipated changes to trade procedures for exporting and importing with Europe. At the end of the session, we'll have some time to address individual questions. So please, can you add your questions to the Q&A function or just type question and we can unmute you to hear it. As you're aware, the session's being recorded. So please do fill in our feedback form at the end so we know what further support you require. And so over to you, Tim. Thank you.
Thank you very much, Christine. Good morning, everybody. My name is Tim Hiscock. I am an export development and international trade advisor at Strong and Heard. Strong and Heard, we've been very happy to work closely with the Greater Birmingham Growth Hub over the last couple of years. We've been around for 26 years, in fact. We've got an office in Manchester, a place I haven't seen for over a year as it happens, but we've got an office in Manchester. We started out, well, they started out, because I'm a relative newcomer to the company, they started out 26 years ago, first of all, as an outsourced shipping office for some large manufacturing companies to sort out all their exporting, all their paperwork, and actually arrange the physical movement of their goods. That's still a part of what we do, but the main part of our business now is training and consultancy. We run a wide range of export and import related training courses. Used to do those face-to-face. Now they're all being run online for the time being. We may go back to face-to-face, who knows? But we found that the online experience has been pretty positive on the whole. Now we run courses in all sorts of export related areas: customs procedure, export development, export licenses, VAT, you name it, all sorts of things that affect a company that's trading internationally. We also do a lot of in-house consultancy and in-house training for a lot of our clients as well. I've been working on sort of Brexit related stuff for a couple of years now. Before I joined Strong and Heard 3 years ago, I was a European sales manager for a New Zealand company that made medical devices. So I think that's kind of why I landed with quite a lot of the Brexit work when Brexit became a hot topic. So that's us, that's who we are. And we're going to look today at a Trading with Europe update, looking at where are we now and where are we headed. I'm going to spend a little bit of time very, very briefly painting a picture of what Brexit meant to people who are trading with European companies. And then we're going to move on to some of the things that have changed, some changes which are coming up over the coming weeks and months. It has been a bit of a moving feast, and it's the effect of Brexit is going to continue to be felt for some time. I expect to speak for about 40 minutes. I suppose it depends how fast I talk, and then we will have some time for questions and answers. The session is being recorded, as you know. I think the material will be available to you. I also refer to a lot of links to websites. I don't have time to go into them today, but you will get a copy of all the links I'm going to be showing on the slides in case you want to use them for yourself later. So without more ado, let's get going and let's look at our agenda today. As I said, I'm going to start with what's happened so far. What has changed over the last year? In fact, it's nearly 2 years now since we actually left the EU. I'm going to look at a thing called import easements. You may have heard quite a bit about this, and if you're an importer from the EU, this is very important to you. Briefly going to look at the Northern Ireland Protocol, which, as you may know, is in a bit of a quagmire, really. If you trade with companies in Northern Ireland, it's likely to be a very, very important issue to you. And we're going to look at trade agreements with the rest of the world. What has happened with our trade relationships with countries outside of Europe. Then I'm going to look at more sort of employment and other non-directly trade-related issues, employing EU nationals, and what happens when we are working, or if we send an employee to work in an EU or an EEA country. Then we're going to look at CE marking and the new UKCA mark, which is being introduced in the UK. And then we'll look at data protection and sharing of data between the UK and the European Union, and we'll look at VAT. So this is the Brexit timeline. As you know, on the 31st of January 2020, the UK left the European Union. What happened in terms of trade at that time was very little. As we will see, because we went into a transitional phase where, although we'd formally left the European Union, we stayed in the customs union and the single market. Those two things are crucial to trade. The customs union meant that there were no being in the customs union meant there were no customs controls and no duties to pay on goods moving between the UK and other European Union countries. Being in the single market meant we had a common set of rules, which meant broadly, and the single market was always a bit of a work in progress, but it broadly meant that if something was legal and suitable for sale in the UK, then it could be sold in other European Union countries too. It was the 23rd of December was another big date just before Christmas. We've got a slightly early Christmas present. During that year of 2020, the big question was, will we leave with a trade agreement or won't we? And the big difference that made was whether there would be duties paid on the goods that we sell to the EU and the goods that we buy from the EU. 23rd of December, we've got a trade and cooperation agreement, and quite a good one in many ways, because it meant that any goods which met origin rules, which I'll talk about very briefly, anything at all, could be bought and sold between the UK and the EU without any tariff. For many companies, that was a very important statement. So that came right at the sort of the last minute, really, almost in stoppage time. We got the trade and cooperation agreement because just a few days later, we left the single market in the customs union, and that is where the big changes happened. Now, that trade agreement didn't mean as much as many people thought. There was a wide range, widely held impression that if we had a trade agreement, that when we left, things would carry on more or less as they were. That was patently not true, as I'm sure many of you can testify. I've been using these graphics for several years now. I think they show very, very clearly what leaving the European Union means to trading companies. When we were in the European Union, as I was trying to explain a minute ago, goods were in free circulation. We didn't have to declare, with some exceptions, we didn't have to declare goods when we were sending them to another country within the European Union. As I said, I was managing a distribution network across Europe for a New Zealand company. And in those days, it was pretty straightforward. I might get a call or an email from one of my distributors and say, I desperately need some stock. And I could just pack it, arrange it, get a courier to pick it up, and off it would go to their country. If your trade was over a certain threshold, then you had to fill in an intrastat report. But that was done retrospectively. You didn't have to do anything to get permission for your goods to leave the country. You could just send them, with some exceptions. So that free circulation we really enjoyed. There was no duties to pay. There was no export declarations to fill in. Your customer didn't need to fill an import declaration. There was no certification or compliance requirements. And there was no need to show country of origin either, because that made no difference either. So goods were in free circulation when we were in the single market in the customs union. As soon as we knew we were leaving the customs union, the single market, whatever happened, that free circulation went. And that is no longer the case. Goods are now subject to customs controls, just as they are when we're trading with countries around the rest of the world. So that went on the 31st of December last year. Another thing that also was important, which was a major change, when we were in the European Union, goods could be imported to a European Union country, as we see here. Duties were paid when they reached that country, and those products were also in free circulation across the single market. That has also gone as well. So any companies who are importing goods, like my previous employer did, we imported goods from New Zealand and we shipped them around the European Union. That can no longer be done duty-free because we're outside of that customs union. And the free trade agreement only applies to goods which are of UK origin. Or if we're importing, they only apply to goods which are of European origin. So anybody that set up a distribution hub, as we did in the European Union, the UK wasn't such a good place to be after all, because there was customs checks and there was the possibility of paying duty on the goods twice. In effect, there are ways around that, which I don't have time to go into today. But on the face of it, we'd import the goods into the UK, pay a bit of duty, and then if we re-exported them to Germany or to Poland, a bit more duty would be paid again. So the model didn't work anymore. So those are the big changes that leaving the European Union meant. And it was leaving the customs union and the single market that really changed our trade relationship. So what does that mean in practice? For a start, as I said, export declarations and controls. Whereas we used to be able to just send goods, now an export declaration has to be completed in advance, and that is done online. And we need to get a message back for clearance, a green light, before those goods can actually leave the country. There are controls on some goods which weren't there before. When the goods arrive in our customer's country, an import declaration has to be done, and there are more controls and more questions and the possibility of taxes and duties. We then need evidence of compliance sometimes. Some of these things are being phased in, but when we're exporting goods, we might need a health certificate or a veterinary certificate, for example. We may need to prove now that our goods comply with the rules of the European Union. And a painful lesson for a lot of companies was that once you're outside of that customs union, those countries start behaving like individual countries, like the individual countries they actually are. And you may find that one country has particular regulations and restrictions and requirements that another country doesn't. So exporting to one European Union country can be quite different to trading with another. And that makes life particularly confusing. And of course, potential delays. And we're living in a time when, obviously, with all the effects of the pandemic and the lockdowns and things, delays have become intolerable. And Brexit was just one more layer on that, really, just slowing things down a little bit more, which caused problems. And not least, of course, all of that means costs. Cost on the business, which weren't there before, which is a challenge in remaining competitive in these markets. So in one slide, that's kind of what Brexit really meant in terms of our trade relationship. And it was the same for European Union companies exporting to the UK as well. So to trade with the EU now, the first thing we need, I expect you all know about this, is an AORI number. You only needed to have one of these if we were trading outside of the European Union. Now we need one for trading in the European Union as well. An AORI number is very, very simple to get for a registered business. It's applied for online, and in most cases, it's your VAT number with 3 zeros on the end, as simple as that. But that is the identification that customs need when we're exporting goods. The first thing they want to know is, who are you? And we are identified by our AORI number. Then we need tariff numbers for our products. I'm not going to say an awful lot about tariff numbers today. For many companies, identifying the right tariff number for our product can be a huge challenge. For many companies, it's dead straightforward, but for some, it can be quite complicated, especially if your product is a bit niche, or if it's a bit complicated, or if you've got a processed food product, for example, that can be quite a challenge. But that tariff number is crucial to customs, because the first things they want to know is who are you and what is it that you're exporting, and that is defined by a tariff number. And it's our responsibility as exporters and importers to identify the correct tariff number for our products. That information opens up a whole range of detail and facts which will affect how our export proceeds. If we've made the product, or if the product's been made in the UK or is of UK origin, we need to provide a statement to avoid duty payments. That has been put forward in a very, very straightforward way, as you might be aware. Origin statements are not complicated. We don't need special forms for them, but we do need to be able to give a statement, and we need to be able to demonstrate that it's true, because that could be checked by customs after we've done that. And we need a declaration. So the declaration is not normally done by an exporter. Most exporting and importing companies use a third party, usually the person arranging the movement of the goods, to do that declaration for them. But beware, because that declaration uses the exporters or importers EORI number. The declaration is in their name, and they are responsible for its accuracy. And at any time, customs could come back and check on that and look for evidence and check on the accuracy. And you can't say, well, it wasn't me who did it. The agent was acting on your behalf. So we do need to be sure that the information we've put into that is very, very accurate. Briefly, finding the sort of information we need, and I stress that all of the links I've got in this presentation are available on a sheet which the organisers will provide for you. There's a link there to finding tariff numbers for our products. There's a link there for finding out what we need to do to export to the rest of the world. That's a very, very useful link there, actually, a new service on gov.uk. Once we know the tariff number for a product, we can go into that armed with that tariff number and the country that we're exporting to, and it can give you a very comprehensive list. It can tell you any duties that will be paid when the goods arrive in that country, and what documents will be needed in order to get those goods into the country. So very, very useful information there. I have another link there at the bottom for finding what we need to do for export to the EU. Now, just to be clear, that second link, the gov.uk, also covers the countries within the EU. I am suggesting that certainly for the time being, when we're trading with the EU, the bottom link is better. This is the European Union's website, Access to Markets, used to be called the Market Access Database, had a bit of a facelift this year. And we are finding at the moment, at least, the information there is a little more comprehensive than what's on gov.uk. That will probably change in time. But I'm saying that for the moment, if you're exporting to the EU, I would recommend using the European Union one. If you're exporting to the rest of the world, you can't use the European Union one because it's restricted, but the information is on gov.uk. So that's important information. That's how we can understand what is going to be required to export our goods. Now then, last year when the COVID pandemic broke, we certainly thought that the government might delay the full departure from the European Union. They had the power to do that, and they decided not to use it. But what they did do was delay the full implementation of controls on imports from the European Union. They have now extended those delays twice more. And the latest dates on this are as follows if we're importing from the European Union. 1st of January 2022 border checks on standard, that's non-controlled goods. Now, if you want to know if your goods are controlled or not, there is a list on the gov.uk website of what they consider to be controlled. Essentially, it's anything which is an excise good like alcohol, tobacco, petroleum, anything which is a dual-use good or has a military application, or certain things in terms of things like art and antiques and things like that. Most goods are standard goods. At the moment, they do not need a border check when they arrive from a European Union country. And we don't need the pre-notification on food and agricultural goods. So anybody importing food and agricultural goods, 1st of January 2022 is a big day because that's where these changes, these full changes are going to come into effect. And then 6 months later, on the 1st of July, export health certificates will be required for products of animal origin. So in essential is what's happening on imports. At the moment, we've left it easier for us to import goods from the European Union than they would have been. And those changes are going to come to effect over the next few months. So look out for that and be ready for it. At the moment, if you're importing goods from the European Union, while there is no check border control, you have to provide a full import declaration within 6 months of those goods arriving, and that hasn't changed. So anything we're importing from the EU at the moment, we have a responsibility to complete a full import declaration within 6 months of the date those goods arrived in the UK. Very, very briefly, let's look at the Northern Ireland Protocol. I'm not going to go into this in great detail today. The bone of contention on the Northern Ireland Protocol, so the overall objective was to maintain an open border between Northern Ireland and the Republic of Ireland. It was part of the Good Friday Agreement, which brought peace to Northern Ireland, and it was a crucial part, everyone agreed, in the nature of the terms of our Brexit. So everyone's agreed that we should keep that land border open. What we've done in effect is we've left Northern Ireland in the single market and following customs union rules. So they're much more closely aligned to the European Union than the rest of the UK. That means that there are some checks required on goods moving from Great Britain, that's the mainland Great Britain, into Northern Ireland, which weren't there before. There's quite a lot of help available there. There's a facility called the Trader Support Service, but there are checks and there are declarations that need to be made. And the crucial question that customs want to know is, are these goods at risk of moving into the Irish Republic, or are they intended for final consumption within Northern Ireland? So a complicated area, a tricky area, and as you might be aware, the protocol has been delayed indefinitely. A grace period on this arrangement has been put in place while our government and the European Union try to hammer out some new terms of trade. So Northern Ireland is a real watch this space at the moment. It's caused a lot of problems for a number of companies, and we're waiting to see what might be agreed moving forward. Now, trade agreements with the rest of the world. This has turned out quite well. When I was doing a lot of training courses around the country before Brexit, this was quite an area of concern because the European Union has negotiated trade agreements with something like 80 countries around the world, which is a lot of countries. And it meant that as an EU member, we were able to export goods duty-free or at reduced duties to many, many countries around the world. The good news is that virtually all of those trade agreements have now been negotiated by the UK government. Some of them are temporary, some of them are going to have to be revisited, but as things stand, nearly all of them, and there are only three exceptions really. They are Algeria, Bosnia-Herzegovina, and Montenegro, which are not big markets for most people, let's be honest. But most of the agreements that we've had have been replicated. Just one word of warning on that, though, that we used to have an agreement which was between the EU and the other country or countries. Now, of course, it's with the UK and the other country or countries. So that means that a company that was buying goods from Germany, for example, and then selling them to one of these countries like Chile or Mexico or Japan, That was fine because the goods were of EU origin. Now the goods need to be of UK origin. Now, while there are complicated rules on a thing called cumulation, which means that EU origin can be accepted, if we were just selling goods which we hadn't processed or changed in any way that were of EU origin, the new trade agreements don't help us. So some companies have fallen through a gap there. Even though the trade agreements are in place, it doesn't apply to them because their goods don't meet the UK origin rules. Haven't got anything to say about the new agreements we're planning today. You may have heard in the press about that. We've got an in principle trade agreement with Australia. We didn't have that before. And we're looking at membership of the thing called the CPTPP. I'm not going to get too much detail on that today, but that's where we are on trade agreements. Moving on to employing EU nationals in the UK. Now, many companies were concerned about this, and EU nationals who had the right to live and work in the UK while we were part of the single market have had to apply for settled status in order to stay in the UK. Hopefully, most people have done that, and anybody who is a national of one of those countries. This extends beyond the 27 countries of the EU. It includes 3 countries who are the EEA countries. That's Norway, Iceland and Liechtenstein, and also Switzerland. Any nationals of those countries who now have settled or pre-settled status have the right to work or continue to work in the UK. Anybody wanting to come to the UK now must apply for a visa, and there is a point system which applies to them. If we as an employer want to recruit somebody from anywhere in the world, not just from the European Union, we can act as a sponsor to their visa application if it's an applicant that we're seeking to employ. Information there, and again, it's on the list about the information about visas and immigrations and work visas, the rules about employing somebody from another country in the UK. What about when we're working and traveling in the EU? We haven't been able to do too much of that lately, but employers working even for short periods in the EU or the EEA or Switzerland may need a visa. Once again, like I said before, we're now dealing with 31 countries, in fact, when we include the EEA and Switzerland, and each of them has their own individual rules. We are a third country to those countries now, and they will treat us like citizens of any other countries around the world, and they will apply their rules if we want to go and work in their country. Now, many companies will send somebody abroad on business for various reasons. It could be a salesman, for example, visiting clients looking for business. It could be somebody attending an exhibition. It could be somebody who's going in to install equipment or to repair equipment, or perhaps deliver some training for customers who are going to use our equipment, or perhaps we're a service company and that's what we do. It's complicated now. Every company has different rules about this, and we may need to apply for a visa in order to legally work in another country. We may also have to pay national insurance or the national equivalent in the country of employment and also pay it in the UK as well. So there could be a cost to us there when we're doing this. Usually, now the rules do vary from country to country, but in most cases, if we're sending a sales rep to visit customers or potential customers, or if we're attending a trade fair, that's not usually classed as working, but the rules do vary from one country to another, so we need to check. And we also need to be very, very careful about this 90 and 180 days rule. Our passports allow us to be in the European Union for 90 days in any 180-day period. If a company is sending somebody extensively into the European Union, we need to watch that. We also need to, of course, bear in mind any holidays or any travel that they've undertaken outside of work with us. We need to check in advance when we're arranging this, which is a bit of a nuisance because we used to be able to just send people at the drop of a hat to do something in another country. Now we need to know what the arrangements are for every country where we want to work. So working and traveling in the EU has brought in a few complications. Now we'll move on to the CE marking and the UKCA marking regulations. For years, we've had the CE mark, we've got used to it. It's a familiar sight. We've left the customs union, we've left the single market, and we are introducing our own standards. Now, the UKCA mark, you can see at the bottom of the screen there, is being introduced as a requirement on goods that carry the CE mark. The rules, as they stand, are exactly the same. We haven't changed the trading standards, we haven't changed the extension of goods which require this mark. So if we're selling goods which have the CE mark and we have done our own assessment, or if a third party has done an assessment for us, then there has been no change to those standards and those regulations. So in that respect, that hasn't changed. If we've done the assessment ourselves, that assessment is still valid. If it's assessed by an authorized body, so some products we have to go to a third party, usually to do with the level of potential risk to do with the product. So if you're making passenger lifts, for example, you need a certificate from an authorized body before you can apply CE mark. Brexit means that CE mark must be authorized by a European Union authorized body. The bodies that were authorized bodies in the UK have lost their authorization. And usually that just means transferring the files from the UK body to somebody else in the European Union who has that authority. The other thing that's come up is the requirement for an authorized representative. If we're exporting CE marked goods into the European Union, we now require an authorized representative who will be our representative in the European Union and will be the point of contact if there is any question about our product in relation to the CE mark. Information is available there on the gov.uk website on placing manufactured goods on the EU market, particularly with reference to CE marking. So look at how Brexit affects you there. If you're exporting anything like a toy or an electrical product or a medical product or many other products as well, which carries the CE mark. Now, if we're importing and selling goods in the UK, as I mentioned, the CE mark is being replaced by this UKCA, UK Conformity Assessment. Different arrangements for Northern Ireland, and this comes up time and time again. There are a number of areas where Northern Ireland has to take a slightly different approach, and I'm not going to go into the detail of that today. Bit of breathing space for us, however. The UKCA mark was going to be mandatory from the 1st of January 2022. That has now been put back by a year. So that is now going to be brought in from the 1st of January 2023. And a link there about using the UKCA mark in the European Union. As I say, if you're a manufacturer of products and it carries the CE mark, adopting the UKCA mark shouldn't put too many problems in your way, because we're not, for the moment at least, talking about changing any of the product standards themselves. Now we move on to data protection. And there's some good news here as well, because it took until the 28th of June, but at that stage, the European Union approved adequacy decisions for the EU GDPR. What does that mean? It means that they've said that our regulations, our laws comply with their requirements, and therefore personalized data can flow freely from the European Union to the UK in the majority of cases. So that's a step forward. We didn't know if that would happen. It's a very welcome decision and will certainly help companies who are trading. For example, if you're trading with on a B2C, if you're trading directly with consumers in other European Union countries and you want their personal details, name and address, bank details, etc. Or if you have a website and you invite people to sign up for a newsletter or something like that, that data flow is now able to continue as before. If you're a UK business organisation with an office or branch or other established presence in a European Union or EEA country, or if you have customers in those countries, you need to comply with both the UK and EU data protection regulations. And you may also need to designate a representative in one of those countries. Again, there's information there on the list of links if you need that. So data protection has become a little bit easier over the last few months, but we do need to be sure about what we're doing there. EU GDPR, so the regulations on data protection, which were brought in just a couple of years ago, may still apply if you operate in the European Economic Area, or offer goods or services to individuals, or monitor the behaviour of individuals in those countries. The Information Commissioner's Office has all the information you need to understand what your requirements are. So our requirements under data protection have changed a little bit over the last few years, over the last few weeks and months. So look out for that. Data protection, it's something which affects every business. We all need to understand our responsibilities under the data protection regulation. The recent changes have at least made that a little bit more achievable. Now we come to VAT. Now the first thing about VAT is that because the arrangements on trade have changed. Now we're going to say something outside of what's on this this slide here. No, cancel that because it's covered on the next slide. First thing I want to talk about is PVA, postponement of VAT, which you might be aware of. We brought in a new system, or the HMRC brought in a new system on imports of goods from the 1st of January to coincide with the date that we left the customs union. If they hadn't, it would have meant that we were going to have to pay VAT on all goods being imported from the European Union, and then we would reclaim it through our VAT returns. And that could have meant quite a big cash flow impact because a lot of our imports come from European Union countries. Rather than doing that, the government brought in a system called postponement VAT for all imports from anywhere in the world from the 1st of January. And that meant that a VAT registered business that was importing goods, whether from Europe or whether from anywhere else in the world, rather than paying the VAT, there was the option to record the figures, the value of the VAT on our regular VAT returns and do it that way. So we weren't paying money in to take it out later. So it relieved the cash flow on that. Any questions you've got about PVA, it has raised quite a number of questions for quite a few of our clients. It's not quite as easy and straightforward as it sounds. There's a link there to the guidance about how we can do that. So postponed VAT came in, which certainly saved us a number of headaches in terms of importing goods generally. But it's different for when we're exporting goods to the European Union. Now, first of all, we have a very big responsibility in terms of VAT when we export goods. When we sold goods to the European Union before Brexit, we would not put VAT on the invoice. We would show the customer's VAT number on our invoice, and we would complete an EC sales list to show the VAT movements, and the VAT obligation would be picked up by the customer in the customer's country and their VAT authorities. Now things are a bit different. When we export goods, we do not have to charge VAT, but we do have a responsibility, a very, very important responsibility, to collect and retain evidence that those goods left the country. And that's usually something we'll be relying on our freight forwarder to have. And that's one thing that's absolutely crucial now. We don't have to show our customers' VAT number on the invoice anymore, but we do need to make sure that we obtain and that we retain evidence, in case HMRC asks us for it, that will show that those goods actually did leave the country. That's the first part. The second part of VAT is, again, when we export goods to the European Union, every European Union has its own VAT rules. Now, the VAT effect of Brexit, in many cases, is very little. Some countries like Netherlands, Germany and Ireland have a system like the postponed VAT I've just described. So the fact that we've left the customs union doesn't make too much difference to your client. They're not going to be paying anything out. They might do the declaration a little bit differently, but the financial effect on the business in terms of VAT is not that great. But in some countries, and Italy is a major example, if we're now exporting goods to Italy, and if those goods attract VAT, then the customer will pay VAT on the import of those goods. He will pay it out, and he probably won't get it back for 2 years. So that is the VAT impact on our trade with a customer in Italy. I've got a link there to the European Union website, which explains the VAT rates and the VAT rules in every European Union country. But it does have a major effect in terms of our selling goods in the European Union. Now we come to a new arrangement called IOS, Import One-Stop Shop. And this is affecting a lot of people who trade lower value goods, especially if you're selling directly to end users. So if you've got a website and people are buying things on your website, for example, this is a major change for you. The EU's e-commerce package introduced changed, from the 1st of July, past tense, in respect of imports of low value of goods into the EU or Northern Ireland. The package also introduces new rules for supplies made through online marketplaces, which has obviously become a very popular way for companies to reach clients. Goods of low value, whether in consignments with an intrinsic value not exceeding £135 or 150 euros. 2 new IT systems have been introduced, one for the collection of VAT on imports of low value consignments, and the other for the collection of VAT on intra-EU business to consumer transaction of goods. The low value consignment relief has been abolished, meaning VAT is payable on consignments with a value of goods up to £150. I know some companies have been concerned about this, and this is an issue which is causing them problems. A business not established in the EU or Northern Ireland wishing to register for IOS will be able to do so in any member state or in the UK. However, at the moment, the IOSS registration portal in the UK is not available. Further guidance will be provided when the system is available. Businesses in Great Britain will make sales of goods in consignments not exceeding £135 to customers in the EU will have the option to register for IOSS in the EU. As the IOSS scheme is an EU system with use and access governed by EU law, businesses that opt to use IOS will need to follow EU guidance, which also sets out what this means for Great Britain businesses and the requirement to appoint an EU established fiscal representative. So things have got a bit complicated. Essentially, we, the exporter on these low value shipments and the business to consumer shipments, are obliged to charge the VAT applicable in the customer's country. It's a complex area. It's causing some companies quite a few headaches. At the moment, one thing I can say is there are a number of financial companies who are setting up services to enable companies to do this. If you're trading all across the European Union, you need a VAT registration in every one of the European Union countries you're trading with. But as I say, there are already companies setting up services which can help to deliver that. Right, we're just about on time. I've gone through quite a few things there. I hope some of that's been useful for you. Now I'm going to hand back, and we're happy to take any questions that you may have.
Oh, that's great, Tim. Thank you so much. It was a really useful update, and you managed to cover an awful lot in a limited amount of time. So I'm sure everyone found it helpful. So as you say, we do have some time now for question and answers, and there are a couple already there. We've had a couple sent in as well, but everybody who did send a question, if we don't get to cover it, then obviously we can follow up after the webinar today. Could I please ask that everybody completes the feedback form, which I've put in the chat? So there is further support available from the Growth Hub for your company. So this is a useful way to let us know how we can help you further. So the first question that I can see in the chat is, do you need a work permit or visa to undertake volunteering work in the EU? And that was from Naomi.
Thanks, Naomi. Hi. Yes, unfortunately, you do. The question of whether work is paid or not is not relevant, and most of the websites you go to, it may vary from one country to another, but as a general rule, unpaid voluntary work will still be considered as work, as would an unpaid internship, for example, or placement in a company. So I'm sorry to bring her bad news. You'll need to look into that.
That's great, thank you. The second question we've got is, we're a small confectionery business, UK origin products, looking to sell into EU markets. What are the main considerations for selling food products into EU markets? As I'm told, these are non-harmonised goods, so different rules will apply according to which markets we target.
Yes, you're absolutely right about that. You're into an area of non-harmonized goods. And that's why when I was talking about the single market and saying how goods were usually could be sold across all markets, this is one of the major exceptions, unfortunately. And many countries will have their own particular rules, their own particular regulations on a particular product. To find out specifically about your product, the first step we need to do is identify what the tariff number is for your confectionery products. That's something which people at the Growth Hub may be able to help you with. There's help online in terms of finding that. You may already know your tariff number. If you do, you're well away. If you then go to the Access to Markets database, the link that I showed earlier today and is on the handout which you're going to get, that you can go in there with just the information of your tariff number and the country you're going to. And if you scroll right down, you'll be able to find information which is specific to that country. And that should be able to help you. Now, this is a complicated area. And in most cases, I think that a lot of companies have had to sort of learn this the hard way, really, and have found that they've caught a nasty surprise because the rules, they were not easily understood. So in most cases, this is where it's really, really helpful to have a representative in the country that you're selling to. So if you've got somebody in the food business, if you've got an importer, if you've got a distributor or even an agent representing you, somebody on the inside who will have a deeper understanding of what those rules are. It's one of the most complicated areas. It's not impossible, but it's somewhere that needs thought. But your first step, find your tariff number, go to the Access to Markets database, put in the country name, and that will bring you up a list of the requirements for that particular country.
Brilliant. Thank you, Tim. We've got a few more as well. So Lisa asks, we're registered for VAT in Italy, Germany, Spain. We're struggling with the authorised representative and EU address needed, especially for selling on Amazon. Do you have any information on this?
Right. Okay. You're selling on Amazon and you're registered for VAT in 3 main European Union countries. And then you mentioned the authorized representative, which is a term used in terms of CE marked products. So assume that's what you're referring to there. Now, any product that carries the CE mark, we must have an authorized representative in a European Union country. That can be almost anybody, actually. It doesn't need to be anybody with a particular qualification, but they do have to be identified, and we do have to name that authorized representative. Some companies, the company I used to work for, actually got one of our distributors to do it for us. Some companies will use an independent commercial service, and there are many companies out there who will be your authorized representative and take on that role for you. Or you could use, as I say, it could be a major customer, it could be a contact that you've got, because really the role of the authorized representative is little more than a postbox, really. It's somebody you can refer to, say, I've got a problem related to the CE mark on this product, and all the authorized representative is really going to do is pass it back to you. So it's not like it's somebody who carries a particular qualification. So it's something you do have to do if you're selling CE marked goods, but the way that you approach it is entirely up to you. I hope that helps.
Brilliant. Yes, thank you, Lisa. And if you need any further information, let us know on the feedback form. The next question is from Alison. Hello, Alison. If a number has an iOS account, do they still need a VAT account in the member state that the imports come through, or is a fiscal representative enough?
As I understand it, Alison, they will need a VAT account. If you're working with the fiscal representative, be guided by them. This is a new area, and certainly the understanding I've got from what I've read is that you would need a VAT account in each country. Whether the fiscal representative can use their VAT account, to be honest, I'm not quite sure. But happy to check on that actually, because I'd like to know as well. But I think, from what I've understood, you're still the company is going to need its own specific VAT account.
Brilliant, thank you. And Lee asks, my company deals with repairs and services on products, and we're having difficulty with how to move the products back and forth in Europe. Is there a right way of avoiding additional import duties for both ourselves and our customers?
Yeah, thanks for that question. Yes, there is, and you're absolutely right. This is where you get a bit hit by these rules. First of all, there's the question of VAT, which might be a problem, but there's also one way or another you're going to get hit by duty, because when you're shipping goods to and from the EU, they'll only qualify for duty-free status a maximum of one of those two times. Because if the goods of European Union origin and they come into the UK, that's fine. But when you're shipping European Union goods back to the UK, that doesn't qualify for duty-free access. What you can do, there are a number of ways to import goods temporarily. Now, it sounds from what you're saying that you're doing this on a regular basis, that this is essentially or largely what your business does. And if you're moving goods on a routine basis into the UK from the EU or any other part of the world, there are facilities called inward processing relief and outward processing relief, and other European Union countries do this too. Now, it's not the most straightforward thing to get. First of all, we need to apply to HMRC. We need to fill in a form. We need to show them that we're capable of running a reliable system which will control these goods. What happens on inward processing relief is the goods come into the country without paying duty, and they're monitored, and then we need proof that they've left the country again. And then as long as we're obliged to provide that evidence the goods did leave again, and then the duty question, the duty liability is waived. That can be done in a European Union country as well the other way. So they can apply for outward processing relief, meaning that when the goods come back, they don't have to pay any duty that way either. It's a fairly complicated area. There's information on gov.uk about inward processing relief and outward processing relief. It's probably the most suitable system for what you're saying, although it may depend on more detail. Have a look at that. And if I'm allowed a little plug there, Strong and Heard do help a lot of companies with things like inward processing relief, and a similar thing called customs warehousing, which is where we're not actually processing goods, but they're coming in temporarily. We've helped a lot of companies set up their system and to work it successfully. Of course, there are other places you can go, but that is probably the way that you need to go in order to avoid those duties and VAT.
Brilliant, thank you. And as I say, Lee, if you want to follow up on the feedback form, we can get back in touch with you with further information. And next question's from Keith. Hi, Keith. It's a short question, but I've got a feeling it's a bit of a can of worms, possibly. Can tariff rates or UK content rules on specific goods change in time, which could alter origin requirements?
Yeah, the short answer is yes. So yeah, so we're looking at tariff rates and content rules. The content rules, anything can change at any time. The content rules, so we're talking about every product. I didn't go into this in too much detail, but when we're talking about we're exporting something to the EU, and to avoid duty payments, we need to be able to say that those goods are of UK origin. That gets a bit complicated because different tariff numbers have different tariff rules. Sometimes it's simply what they call CTH, change to heading. So if I started, for example, with a ball of clay and I've made a teapot, it's changed its tariff number because it used to be a ball of clay, now it's a teapot. That's all they want to know. Doesn't matter where the clay came from, I've got a new product. Other ones, it's a question of the percentage of non-originating material. So in some products, certainly in food and things like that, they want to know how much of the product was UK, how much was from another country, and so on and so forth. All those regulations are laid out in the Trade and Cooperation Agreement, which we signed last December, which is substantially why it runs to about 1,200 pages, because it's got all this information in detail. Luckily, it's all on a website now, so we don't need to pore through all those pages. In principle, yes, that could change any time, and it's important to keep up to date with those things happen. We're not expecting any changes, and they don't happen a lot. Where we could perhaps be keep ourselves up to date on that is if we go to the HMRC website and subscribe for updates. There is a page there where we can subscribe for email updates, and that's probably one of the most useful things you can do there. Go to that link. I haven't included it on the page, but if you Google HMRC and go to the site, you'll find there's a whole range of different tick boxes, and tick as few as you need, because you will get loads of emails every week if you don't. Tick the ones which are relevant to you, and that should mean that if any changes are brought in, you will get an email from HMRC in advance. I wouldn't expect these things to change regularly, and I would expect there to be quite a lot of talk about it before it did. But in principle, unfortunately, you're right that these things can change all the time. Now, just going to talk about tariff numbers as well, because they change from time to time. And from the 1st of January 2022, there was a major change to the harmonized system, which is the international system of tariff numbers that we use. There is online and also on our website, I have to get a few plugs from time to time, a correlation table that shows you which tariffs we currently have are going to be changing next year. That's all on gov.uk. So do look out for that, because from time to time, the tariff numbers themselves change as well.
Brilliant. Thank you, Tim. And next question from Dave. Morning, Dave. We have, oh, it's disappeared off my screen. Sorry. We have an we have an office in the UK, but we'll be expanding more into Europe. We import our product from the head office in the USA, so guess it would be best longer term to look at a distribution hub within the EU. Would this avoid unnecessary VAT?
That could well help you a lot, and choosing which country you put it in might be an important point as well. Yeah, a lot depends on the absolute detail. It depends on how much you're shipping and what the value is. Always worth looking at things like the actual tariff duty as well for your product. I've seen quite a lot of companies, just to point this out, have gone to a lot of trouble trying to avoid duty, only to realize they weren't going to pay any in the first place because the duty rate on their product was nil. Because actually in the European Union, about 49% of tariffs carry no duty. And in the UK, it's about 60% because we've reduced some of ours. So a lot of products, there's no duty to pay anyway. So first of all, look for the easy solutions. I'm sure you probably know that, Dave, but just for everyone else's opinion, look for the easy solutions first. It's a bit like, if your car won't start, first of all, make sure it's got some petrol in the tank before you start disassembling the engine or something. So look for these solutions first, but you're absolutely right. It may well be much easier for you all round to ship directly from the USA into one European Union country and then distribute your product from there. It could be much more tax efficient. Also, it would potentially give your customers a much better service, because you can then, once they're in the single market, you can move them very, very quickly to any country within the European Union. If you want to bring them into the UK, there is a system called customs warehousing, a bit like what I was just talking about with inward processing relief, where you have an approval from Customs and Excise, which allows you to bring those goods into the UK, not pay the duty, and you would only pay the duty if they were subsequently released into the UK market. If they're re-exported, the duty liability is waived. So that's another way you could do it. But that's there's a bit more red tape, a bit more bureaucracy on that. I would think, in principle, I'd be starting with this and thinking, if I can ship directly from the USA into a chosen EU country, I'm going to make my life a lot easier. I'm going to save a lot of money.
Brilliant, thank you. Thanks, Tim. We've got two more questions. One in the chat from Ollie saying, is the estimated quantity Esign likely to need to change on packaging?
I really don't know. I haven't heard any plans to change that. It might be something to look at. You've caught me out there because I don't have a definitive answer for that one. I'm not aware of any proposed changes. That's the best answer I can give you.
Brilliant. We'll stay in touch, Ollie, and we'll keep you posted. But and then the final question from Richard. Thanks so much, Richard. You sent the question in advance as well, the concerns around the iOS. So I'm hoping I don't have to read it all out, and Tim can maybe deal with it straight away, or shall I read it?
Can I see it? Is it in the chat or?
It's in the question and answers. I'll read it out. It
Okay.
says, with regards to iOS, although it came in July, we've only started to face issues from it in the last 3 weeks.
Oh, yeah.
We sell men's fashion accessories online. We sent out about 50 pairs of cufflinks to customers all over the EU a couple of weeks ago. All were sent on Royal Mail International tracked and signed service. We completed the necessary CN22 forms. We had 3 cases, 2 in Germany and 1 in Italy, where the customer was charged €22 in order to receive the parcel, which was their local VAT. Of course, this caused upset with our customers. Do we have to register for iOS, or are we better to find a fully duty-paid service provider such as FedEx or UPS? Royal Mail do not currently offer a duty-paid service, as far as they know. Also, we've been advised if we're going to register for iOS to do so in Northern Ireland. But now I understand that the goods would have to pass through Northern Ireland en route to the final EU destination country. Is that correct?
Yes, thanks for that. No, very, very good question. A lot depends, and you're probably feeling the grief of some of the growing pains of this, and some authorities in some countries not really being aware of the rules yet. But it's an unfortunate situation for a business like yours that the disregard of low value goods for VAT has gone, and that now has to be paid. Now you're shipping directly to end use customers. They don't want to get involved in paying VAT. You want to be able to provide a door-to-door service for them like you've always been able to do. The question of whether you go down the iOS route or whether you use a service like FedEx or UPS, I suppose, is a commercial decision. I would certainly be, if I was in that situation, I would want to look around. I'd want to do my sums, look at the services that other couriers can use, and look at the costs and benefits, and make a decision. It's purely as simple as that. But you do have to take that on. At the end of the day, when you've got a system in place, you should still have a viable situation, because while you're charging the VAT from your customer's country, of course, you're not charging the UK VAT. So it's fairly similar. Now, the other point you've asked, let me try and get my head around this one quickly. Just about Northern Ireland. No, as I understand it, those goods would have to pass through Northern Ireland en route to the final EU destination country. So I don't think that's going to help you. That's my understanding, at least, that it would have to have been it would have to physically pass through Northern Ireland to do that. So no, I wouldn't recommend doing it that way.
That's brilliant. Thank you. We can follow up later, Richard, as well, if there's further queries. But Tim, thank you so much. You really are an expert. So my introduction was exactly right. So we've managed to answer all the questions, and I hope everybody's enjoyed it and managed to fill their feedback form in with further information. So thank you so much. Sorry we ran 3 minutes over, but hope everybody felt it was worthwhile to do so. Thank you all, and see you at a future event. Thanks a lot.
Bye.